province is considering changing the way we do bail in Ontario, and it's an interesting tweak. And there are two things about it where it's going to be criticized. The first one is, will it work? Will this actually be effective at making sure people live up to their bail conditions? Or maybe some people won't get bail at all, and it'll keep some dangerous people behind bars longer. The next one is a little more complicated, and we can leave that up to the legal experts about whether it's constitutional or not. But I think it probably can be constitutional. We haven't actually seen the law. It'll depend how it looks. And the devil is always in the details with the new law. But the idea is this. When you have been arrested and charged with a crime, now you are presumed to be innocent, and that's important. Presumption of innocence. I'm not going to just dismiss that. But once you've been accused of a crime, you're being held, you get a bail hearing. And often you are released under certain conditions. One of those conditions may also be that your surety, the person who says, we will be, in effect, we will be your prison guard outside of jail. It's usually a family member. So let's say you get arrested, and I'm going to say you're innocent. Ooh, the police made a mistake. Just arrested an innocent man. Okay. That doesn't happen as much as people like to think it does, but okay, they've arrested an innocent man. Now your dad comes along and says, yes, these are the conditions we will agree to as a family. And the conditions can be a long list. You're not allowed to be in contact with that person. You're accused of trying to rob a bank. You can't go near banks. You got to be home by 9 o'clock after work. You can't go out on weekends. All those conditions are there. And then often, not all the time, but often, there's also a condition of money. We'll put up, and it's not like in the U.S. We're not going to have some guy named Dog running around, a bail bondsman. We're talking about trivial amounts of money, hundreds of dollars, not very often more than a couple of $1,000s, which we rarely even try to connect, even when the bail conditions are broken. But so a small amount of money is part of that. And what this is supposed to do, people are going to hear this story this morning, and they're going to say, well, if someone is a hardened criminal who's making a lot of money selling drugs, they're not going to care about putting up a couple of $1,000s to get out of jail. It's not going to be a big deal. That's not the point of it. The point is this, and you got to be really clear on this, and I want to be really clear on this. The point is your surety, your dad in this case, who's standing up for you, the money is usually given by the surety. And it doesn't matter if the person breaches their bail conditions. You don't have to pay that money if you do one thing. You're only required to do one thing. Inform the police. That's it. And you're off the hook for the money. So let's say you put down $1,000 and your son, turns out you're wrong about your son. He is a bit of an idiot and he violates his bail conditions. You will get the money back if you pick up the phone or drop by the police station and you say, my son is out on bail. He's supposed to be home by 9. He didn't come home. That's it. You're off the hook. You'll get the money back. Or the way the system works right now, they won't try to collect the money from you at all. By the way, even when bail conditions are broken, they rarely go after the money here. So I think it can have a very strong effect. It's not about making criminals accountable. It's about making the sureties, the people who stood up for them, making sure they do their job, which is to say, yeah, he took off the ankle bracelet and he's gone. That's the job of the surety. And that's what the money is put up in advance for if we have this new system. And it's what they're supposed to forfeit and pay up later under the current system, which brings us to the Constitution. I'm not a constitutional lawyer, obviously, but it seems to me that if we're already asking people to pay after the fact, it's not a two-tiered justice system now. It's constitutional now. Having the pay in advance, there's not a lot of change here. Think that through, because the civil libertarians, they're already clutching their pearls about this one. This is 2 levels of justice. What about somebody's accused of a crime, but they don't have any money? They're not going to be released. First of all, we can leave that up to the discretion of a judge or justice of the peace, what the amount of the bail will be. And we do that now. So it doesn't have to be a huge amount if someone doesn't have any money. But what you're really setting up right now, you have a system that says, because poor people right now can say, yes, I'll give you $500. They don't have the money. They never intend to pay it. So you made a laughing stock of the current system. So all you're really saying is, it's a 2-tiered justice system. There are people who have money and people who are willing to lie that they have the money and never intend to pay it. So I don't have an issue with this on any front, having people pay up front. And maybe in some cases, it should be even more money. And then ultimately, if they've committed such a serious crime or they're accused of such a serious crime that you don't want to release them, then don't release them. The amount of bail that you put up, the money you put up, you and the surety put up is irrelevant because you're not getting out. So there will be no money involved. No, I think this is worth a serious look, and I'm happy the Ontario government has brought it up. It's the Morning Rush. Good morning. I'm Bill Carroll.